Morning, my name is Edie Deal, and thank you for attending the Abuser Registry webinar. We appreciate all the time that you're taking today, and also a few housekeeping matters for the group, especially to get a group. If you're viewing this as a group on a webinar, if you'd like to get continuing professional development, which we have 1 hour approved for, you need to send in that group attendance sheet, and each person must supply their own email address so that we can get out a certificate to you. Once again, I'd really like to thank you for coming. Hopefully, we've done a few sound checks before we started. Everything seems to be looking good on our end, but if it's not, please send us a question and we'll take care of it. I'd like to introduce Scott Phillips, the Assistant Deputy Director and the head of the MUI Registry Unit.
Good morning, everybody. I want to echo what Edie has mentioned and thank you very, very much for being here today. I know in terms of everything that's going on in the world today and all the busy work and activity that's going on out there, you being generous and giving of your time, we very much appreciate it. I do want to say something really quickly related to the coronavirus, and just to let you all know that the MUI unit, will be working collaboratively and collectively with you to try to get us through this time. I mean, as you guys all know, this is an unprecedented time where work is done in different ways, and I have no doubt that together we'll get through it. We'll work well together. We'll make sure that we protect folks as best we can, given some of the limitations that are going to be obviously coming forward, given all the protection that we want to take with the coronavirus. So just want to thank you all for all that you're doing. Be safe yourself, protect yourself, and help protect those that we're here to support. I also wanted to point out that we have a spot on the department's website that addresses the coronavirus situation. If you go to our dodd.ohio.gov, there's multiple resources listed there. So please feel free to do that. All right, so getting started with our webinar today, we wanted to do this webinar related to the Abuser Registry just to give everybody more information. We're so lucky that we have an Abuser Registry here in Ohio. There's only 26 states currently that have them. We were one of the very first to get the registry, and just very thankful for the work that you do and for the progress that we've made. I know probably everybody knows we're approaching almost 1,000 people that are on the registry since its inception. People are doing a terrific job, but we wanted to make sure that we kind of had a webinar that walked you through the steps and the process. I think most people know generally what the registry is about, but today is going to give us some information to talk much more specifically about that. I did want you guys to know that when CMS Special Review team came here back in June, they highlighted our Abuser Registry as a promising practice, and that's a feather in the cap of you and the work that you do. And another reason, again, why we got to continue to improve and grow and get even better. All right, I think at this point I want to turn it over to our presenters. So I'm going to turn it back to Edie to begin the presentation. Thank you for all you do and very much appreciate you being here today.
Hello again. I have 3 learning goals for my section. I want to say again, many of you have helped out with the registry cases. You've testified at hearings. You've gotten back and gotten us videos, statements, everything else that we would need to make a decision on whether a case should go forward or not. And we really appreciate that. So there's 3 topics: the registry placement criteria, the steps to registry placement, and steps after placement on the registry. So the first thing is we need clear and convincing evidence of a registry offense. Clear and convincing is between a reasonable doubt of the criminal standard and preponderance of the MUI closure standard. And everything we do in terms of documentation, in terms of statements, in terms of everything that Beth Atherton will be talking about a little bit later on, is towards reaching that clear and convincing evidence. We need to make sure that the PPI or primary person involved is a developmental disabilities employee, and that's going to be a case-by-case basis. Many times in my next few slides, I'll say generally, because there may be a case where it could be a developmental disabilities employee, other cases it may not. We're going to take those as a case-by-case basis. And you should have a handout, if you don't, it'll be at the end, about what all the definitions are of developmental disabilities employees and everything else. We need to make sure that they are providing specialized services, that they're not just providing services to all people. Sometimes this is nursing, sometimes this is other healthcare fields. The third item for placement criteria is you need to have an individual. You need to have that be the focus and that be the person that is a part of that registry offense. For an example, we have several cases of misappropriation where the item, the camera, the whatever it is really the property of the parent or the brother or someone else, not the individual, or it's the property of the agency in terms of money and that sort of thing. So we're looking at very specific information for all three of these items to go forward with the registry. I've broken the registry offenses down, because that's the first thing we're going to learn about, into 10 different groups, actually 6 different groups of 10 different offenses. So in Revised Code 5123, I'm not sure that you need to know all that, but I broke it down into misappropriation, knowingly abuse, 5 through 7 are abuse, neglect, 8 is prohibited sexual relations, 9 is failure to report, and 10 is convicted or pled guilty. These line up with the actual statute for the registry. We cannot enlarge them, we cannot diminish them. They are what is in the actual statute. So the first 3 are misappropriation. Number 1 is misappropriated property of one or more individuals. Now this is either separately or taken together. So if you had one individual who had $50 stolen, then the next individual 20, then the next individual 60, you could aggregate those together and get to a $100. It can be over time too. Let's say $50 was stolen one week, then $60 was stolen another week. Those could be taken together. So we've done that many times. Number 2 is where the manner of theft, and we really need specifics on this in terms of what was it, a credit card, an ATM card. This would also cover EBT or directions cards, the food stamp cards. And generally, like I said before, it's going to be a case by case. It will not cover gift cards. So we're not sure until we take a look at that exact case, but those may not be covered. Number 3 is prescription medicine. I think that speaks for itself, and we really like that idea of that. Also about misappropriation, we're generally not going to have, like I said, gift cards. We're generally not going to have Medicaid fraud either. So that's generally not going to be covered by the registry, but we're never saying never. So if I'm asked about this in the future at a registry hearing, I'll say it's a case-by-case basis, which it is. So the next one is knowingly abuse, and I would think that number 1 here is the one I want to focus on. The use of physical force that can reasonably be expected to result in physical harm or serious physical harm. Some people are under the mistaken impression that it did not cause harm, so I can't be on the registry. We have had people placed on the registry when there has been actually no harm, but there's a reasonable likelihood, and it reasonably can be expected. It was just lucky, maybe, that the person wasn't harmed. So these are the cases where someone throws things, they even slap at someone, smothering, kicking. Even if it does not result in physical harm that we can show, we still can go forward on a case like that. Sexual abuse and verbal abuse, both of those cases require specifics. And I would direct you to the incident-specific criteria in the registry, in the MUI rule. All of those incident-specific questions relate to registry criteria. So if you answer those, you should be in good stead. Verbal abuse, we need the context of the interaction with the individual. We've had several PPIs say they were just joking. 5, 6, and 7 are recklessly, negligently abuse, neglect. And in those cases, we show the definitions in the handout that I sent out. But you need a requisite physical harm, serious physical harm. The number 7, substantial risk, is a very high standard to make. Prohibited sexual relations, many of these start off as sexual abuse and then are lowered and substantiated to a prohibited sexual relations. But we're absolutely going to need those elements that are listed there as well. Failure to report, and please remember, failure to report is most likely going to be a reportable offense to law enforcement and a criminal offense. Many of those cases, though, you've already reported the underlying, like physical abuse or something like that, that has been failed to report, so law enforcement knows about it. Convicted or entered a guilty plea, this is number 10, and this tracks right with the statute. There's certain enumerated offenses. You have 2907, which is the sexual abuse, 2913, which is the theft violations, and all the other ones are found to provide for a functionally impaired adult, patient abuse or neglect, those sorts of things. Just a note that in most cases, attempted sort of offenses, except the offenses of violence, will not be considered under this category. Next thing is steps to registry placement. I put a slide in there that shows the basic steps. And then I go to registry fields. If you take a look at this, from the very left-hand column, a registry case actually starts from the very discovery and from the investigation portion of it. There are things that we may never get in an investigation if we don't get it at that stage. Registry intake, that's going to be, and these are registry fields that are on ITS. If you ever want to take a look at the drop down of find PPI, and then you have the fields all listed there. So if we request the file, then we receive the file, it's going to be reviewed and either closed or submitted to the external review committee if it's not criminal. If it's criminal, and Honoré Hunter is going to talk about this in more detail, it will go its own path with a voluntary consent or a prosecutor's waiver, which she'll talk about. We also have a notice and service of notice. What that means is there are due process rights attached to people being placed on the registry. And before they can be placed on the registry, they have a notice of opportunity for hearing, in which we have to say, why are we proposing that person's name for the registry? And we have to put in pretty much a lot of detail. We have to have the date, we have to have the individual's initials, it's a confidential key. We have to have exactly what we think they did that resulted in them being proposed for placement on the registry. It says service of notice, that column, there is a lot of things that go on with service of notice. If we can't get them to claim the certified mail, we may end up publishing it. Then there's the hearing. And I have a slide that says what to expect in a registry hearing. If they request a hearing timely, what's going to happen is we will schedule the hearing, and the Attorney General's office, Assistant Attorney General, will be representing us. We will go in front of a hearing officer. They will have a report and recommendation. It is not binding. The director can still make their own determination of what should happen. There will be a court reporter there. You'll be under oath if you're a witness and testifying. They may or may not have a transcript of it. And it will go back and forth between the PPI, and they can be represented, they could represent themselves, and the department's side of things. Definitely, you're going to have exhibits that you're taking a look at. And we need those exhibits to be, those documents to be saying what you think they're saying. And you're going to review those with the AG office, and definitely it's almost like any other administrative hearing. It's not a court hearing. It's not, anything less than that. And we don't have any questions about that, so we're moving on to registry affidavits. Everything that I've said that's a required element for the registry offense, along with it being an individual, a developmental disabilities employee, is in the registry affidavit. And so thank you, all of you who have given me maybe sort of secondary documents or more documents to show, that the employee's been trained on this, that there's other things that can show. Usually it's me signing the affidavit, but there have been a few times where you've helped us out and actually signed your own affidavit for, like, example, an audit or something like that. Next screen is the registry order. The director signs a registry order with a decision, and if it is yes, they are placed on the registry. And if you're not subscribed yet, certainly would want to be subscribed to this. This is an online listing, and if you do sign up for it, within a few minutes, you'll know when a new person's placed on it. Third thing in the registry process is the steps after placement on the registry. So what happens? The first is verification. People call into the number on the registry website. They are told whether that is actually the person, and we're going to verify by Social Security number that's on the registry or not. Annual review, annual notice of the registry. We sometimes have appeals of the orders. So the person is placed on the registry, and then they or their attorney appeal the order. We have never had an appeal of an order be successful, and very few are actually appealed. The next one is an attempt to get attorney's fees. This is the PPI's attorney, and we've never had this been successful as far as I know either. This would be where the hearing officer says, we don't think that the person should be on the registry. The person is either on the registry or not. But if they are said that this should have never gone to this step of hearing, that's actually what the attorney's saying. We have never had that be successful. To get to the registry hearing or to send out that notice, we only need a reasonable basis. So it's not like we have to have an actual clear and convincing case there. The next thing is a petition for removal. And I'm sure many of you have heard of this. What happens is a person is on the registry for life. That is unusual in terms of registries, but they are on there for life unless they have a petition for removal granted. That petition for removal process is a written process. We would need to get the recommendation from the individual or their guardian as well. And it cannot be applied for. A petition for removal cannot be held until 1 year after the date of placement. If that petition is denied, the person remains on, and they need to wait 2 more years from the date of the notarization of their signature on their petition, their initial petition materials. So we have had several people, I think they're on their third petition, and so it's going to be 5 years from the date they initially petitioned. If they are granted the petition, it will be as if they were never on the registry. So those are taken very seriously, and we go through those. And then you have someone who may or may not call you as an investigative agent or as someone associated with the case to ask your recommendation as well. So many of these things require documentation, and the best documentation will allow us to make decisions, either processing the case further and maybe even going to hearing or affidavit and placement, or to close the case. And to close the case knowing that we have all the information that we need to have. So the next person who's going to talk is Beth Atherton.
Hey, hi, this is Beth Atherton, and I'm an investigative agent with the department. Next, I'm going to go over some documentation that you can obtain to conduct a thorough investigation. So when our department requests a substantiated MUI file to review for potential abuser registry placement, as Edie had indicated, the investigation needs to establish that there is clear and convincing evidence that the incident meets registry definitions and requirements to move forward in the process. So in the next several slides, I have lists of examples of possible documentation that you can obtain and review during your course of the investigation to ensure that you've completed it thoroughly. So these lists are certainly not all inclusive and are intended to aid you in finding ways to obtain documentation and evidence to support your findings. So obviously not all this documentation listed in a category may be applicable to the investigation that you're conducting, and it's just simply meant to be a guide. So you'll see some repetition of some important documents to obtain in these next several slides. Okay, so documents that may be helpful during your investigation into physical abuse include the individual support, service plan, the individual health plan, behavior support strategies, incident reports. So you'll want to include all incident reports that were completed regarding the incident or incidents to determine if there's consistency with what was initially reported. You'll want to take a look at photographs of injuries, a detailed description of any injuries or bruising sustained by the individual, or even a lack of injuries. Maybe the PPI stated that he or she was attacked, but lacks any marks or bruising. This would be very helpful with establishing credibility when you're working on your report. So photographs, a sketch, or a description of the scene. So you're looking to see if there's solid evidence that any witnesses could have seen the incident from where they were located. Medical documentation, you may want to request some EMS reports, ER or hospital reports, physician's notes, staff schedule and PPI timesheets. This is helpful to verify contact with the individual and to show timelines. Transportation schedule, transportation routes, police report, court records, PPI training documentation, PPI personnel record, and any previous disciplinary records, video or audio footage, and depending on where the incident occurred, there could even be some store or public video surveillance footage that you could try to obtain. Also, social media posts or messages, text messages, screenshots, phone records, PPI court docket search, an ITS MUI history for the individual, relevant previous prevention plans, SSA, nursing and provider case notes, UI logs, written statements, and an ITS PPI search. And again, you know, these are all intended to just be ideas for you to look into to obtain some additional information for your investigation. So verbal abuse, documents that may be helpful during your investigation would include, again, the individual service plan or health plan, the behavior support strategies, again, incident reports, your sketch or photograph of the scene, include distances. This is important to establish the credibility of any witnesses also to the incident. So was it possible that the witnesses that, that you have found could have potentially seen or heard this verbal abuse that occurred from where they may have been positioned? Again, staff schedule, which again, we're looking to verify that there was contact with the individual and to try to help establish timelines. PPI timesheets, transportation schedule, transportation routes, PPI training records, PPI personnel records, and any previous disciplinary records, video and audio footage. Again, we're looking at possibly some from store or public video surveillance footage. Again, social media posts and messages, text messages, phone records, voicemail messages, screenshots, PPI court docket search, relevant previous prevention plans, SSA and provider case notes, UI log, ITS MUI history for the individual, interview notes, written statements, and the PPI search. So documents that may be helpful during your investigation into sexual abuse include, again, the ISP and the IHP, behavior support strategies, again, your incident reports. You'll want to request medical documentation, staff schedule, and PPI timesheets. Again, you're helping to verify that contact and establish timelines. The police report, court records, video or audio footage, store public video surveillance footage, voicemail messages, social media posts and messages, travel and mileage logs, text messages. phone records, any pictures, request screenshots, and take a look at any criminal history of the PPI, sketch or photograph and description of the scene, relevant previous prevention plans, again, your SSA case notes and provider case notes, ensuring that you're getting the PPI training documentation and the personnel record and any previous disciplinary records, your UI logs, ITS MUI history for the individual, and PPI search. Those are very important when you're doing those ITS searches to include those in all of your reports. So documents that may be helpful during your investigation into neglect would include, again, the ISP and the IHP and the behavior support strategies, incident reports, staff schedule on PPI timesheets, mileage and travel logs, transportation schedule, transportation routes. You may want to look at Google Maps and include your distances, sketch or photograph or a description of the scene, medication administration records, video or audio footage, again, your store or public video surveillance footage, social media posts or messages, text messages, phone records, pictures, screenshots, PPI training documentation, PPI driver's abstract, National Weather Center temperature report. If you're looking at maybe somebody was outside, they've gotten away from the home, you want to be able to verify some information in that way. Medical documentation. You may want, depending on your investigation, request the menus for the individual and the meal preparation instructions for the individual, supervision level documentation, alarm check documentation if that's the incident that you're investigating, staff assignment sheets, written statements, provider, SSA, and nursing notes, a police report, UI log, PPI personnel file, and any previous disciplinary records, ITS MUI search for the individual, plans, PPI court record search, and ITS PPI search. And again, we're looking for that clear and convincing evidence to be able to show that, that the PPI was responsible for what this incident was that it occurred. Okay, next we have misappropriation. So these documents that would be helpful would be, again, the ISP, the IHP, any behavior support strategies that may be relevant, the incident reports, medication administration records. There may be some narcotic count sheets you can request, pharmacy documentation, receipts. So, you're looking at grocery or medication, household items, clothing, and so forth, bank statements, overdraft fees, credit card statements, copies of canceled checks, checkbook ledgers, petty cash ledgers, spending cash ledgers, financial audit documentation, household bills, video and or audio footage, store or public video surveillance, inventory sheets, staff schedule, PPI timesheets, police report, a credit history or a credit report for the individual, rental or lease agreements, copies of bills, disconnect notices, collection letters, documentation of collection phone calls, social media posts or messages, pictures, screenshots, PPI training records, documentation of staff having access to individual money or accounts, PPI personnel record and any previous disciplinary records, SSA and provider notes, UI log, PPI court record search, ITS MUI search for the individual, relevant prevention, previous prevention plans, and ITS PPI search. And again, the more information that you have in these case files, the stronger case that we have. So it's very important that you're digging and trying to find all the information that you can. So next we have prohibited sexual relations. So you would want to, again, take a look at the ISP, the IHP, behavior support strategies, incident reports. Again, you're going to want to request a medical documentation if there is some, staff schedule, PPI timesheets, transportation schedule, transportation routes, court records, video and audio footage, again, your store or public surveillance footage, voicemail messages, social media posts or messages, text messages, travel and mileage logs, and phone records, pictures, screenshots, a sketch, photograph, or description of the scene, SSA and provider case notes, criminal history of the PPI, UI logs, PPI personnel record, and any previous disciplinary record, PPI training documentation, ITS MUI history for the individual, and relevant prevention plans and ITS PPI search. And as I had indicated, there's a lot of repetition in some of these, but they're very, very important that, that you're thinking about these during each of your cases. So when the Abuser Registry unit is reviewing a case for potential abuser registry placement, it is vitally important that all supporting documentation, your written statements you've collected, and interview notes you obtained and reviewed during your investigation are contained in the investigation file. It just makes for a much more solid potential registry case. And again, as Edie had indicated, there might be some times that we may call and request some additional information, but this is just giving you some additional tips on the front end, so you'll have a nice solid case. We do thank you for all you do, and next will be Investigator Honoré Hunter.
Good morning. I'm going to cover the criminal cases that end up occurring as the result of MUI investigations that you all do. And this could include criminal charges that are filed during the current open MUI or subsequent to you completing your investigation. As Edie pointed out earlier, when we are looking at criminal charges that could assist us in the registry process, there are a couple factors we have to take into consideration. We have to make sure that the charges are filed for an individual who is an employee, a DD employee, providing specialized services, and that the victim of the crime has been identified as an individual who is receiving services from that employee. So it's going to be really clear for us to have that information so that we can move forward with the process. Once the criminal charges are filed, it's very important for us to find out so that we know how to move the case forward in the registry process. So as soon as you're aware of criminal charges being filed involving a PPI who is a DD employee and a victim who is an individual receiving services, please contact us, either your regional manager, or you can contact one of the registry investigators just to let us know. Once we find out that there is a criminal charge, we then treat that registry process a little bit differently. There are two different things that we use, the tools that we are able to use in the criminal process. One of the most important things we do is start communication very early with the prosecutor's office. And we can look at presenting them with a couple of options. One of the options is called a prosecutor's waiver. With the waiver, it's something that allows the registry process to move forward even though the criminal case is pending. So, for example, if someone has a criminal charge filed, but they fail to show up in court and a warrant is issued and they can't be located, we don't want that person to just kind of be out there and the criminal case sitting there. The registry process can move forward as long as the prosecutor's office agrees to allow us to move forward. So we would want to know early, and then we would have contact on our end with the prosecutor's office. In addition, if a PPI requests diversion or intervention in lieu of conviction, the prosecutor could agree to allow us to move forward with our registry process, even though criminally that case is kind of still pending because the PPI has to complete their diversion or intervention through the court system. So we do draft the prosecutor's waiver here in our office. We communicate with the prosecutors. It's really helpful that you guys provide information to us on the contact that you have with the prosecutors, the names of the prosecutors, and providing that information helps us along. But we do draft that prosecutor's waiver. We send it to the prosecutor's office for their review. And hopefully once they sign that, we can go ahead and move forward with the registry process. The second thing that we use as a tool with criminal cases is called a voluntary consent agreement. And again, we do work with the prosecutor's office for this as well. This is an agreement that we draft here and then we send to the prosecutors. And it allows prosecutors to communicate with PPIs who are defendants. And oftentimes it's used as part of the plea agreement. And occurs most of the time before sentencing. Obviously, we want some conversation early And it allows us to give the defendant or the PPI the option of voluntarily signing off. They're going to agree to go on to the waiver, and they're waiving their administrative due process. For example, they would not then later be able to come and request a hearing to request that they don't go on the registry. It really streamlines the process of placement, and it gives prosecutors a tool when they're negotiating to try and resolve the criminal case. Again, we draft the voluntary consent agreements in our office. We communicate with the prosecutors about them. We forward the voluntary consent agreement to the prosecutors, who present them to the defendant and or the defendant's attorney for them to sign off. Once we have that, then we move forward in our process. And one of the things we need for any criminal case that we're going to use for the process is we have to get copies of court records, and those copies have to be certified copies. Once the criminal case is completed, we request those certified copies of court records, and we need both initial charging documents, such as an initial indictment, a complaint, or a bill of information. And we also need the final judgment entry. So the reason that the charges were filed has to be very clear in the criminal case and court records, and then the outcome of that criminal investigation. Oftentimes, IAs have been wonderful with helping us to obtain those. Generally, we try and get those on our end, but that is something that we have gotten assistance from you all with, and we appreciate that. In addition, just to be clear, when we get those certified copies, it can't be a copy of a certified copy. It has to be the original from the court. It has to have that stamp seal from the court on them, and they should not be written on or stapled. So if you're assisting us with that process, please keep that in mind. And just for kind of clarification, there are a couple examples. One is an example of an initial indictment. So you can see it's from the court, it has the journalized date, has the filing information, and then the example of a final judgment entry is also present there, just for clarification. Before you close MUIs, when you know there's criminal charges associated with them, if you could just make sure you're communicating with the regional managers even before you submit them for closure. I think one of the things we really want to impress is to have you guys communicate with us on the front end as soon as you know there's criminal charges filed, so we can start that in communication with the prosecutor's office and move those forms and those processes forward. So notify us when you know that there are criminal charges, and if you know the court that it's going to be addressed in, the prosecutor assigned, or any relevant dates. And then everyday ways that IAs can assist in the process is, again, just communication. And then in the ITS, making sure that you use the PPI's legal name and that it's spelled correctly, not nicknames or misspellings. Please include the accurate dates of birth in the ITS, which we use to search for defendants, and include in the case file the name of the court involved, the case number if you know that, the prosecutor's name. Provide that information if you have it, and then in the actual case files, as Beth mentioned already, include the police report, and both the initial crime report and the supplemental report. And with regard to documentation, I'm going to hand it over to Anna Schaefer. She's going to discuss verification and documentation.
Hello, everybody. I'm Anna Schaefer. I'm going to talk with you today about verification and documentation for interviews and other associated information that should or is best practice to have signatures, initials, and/or dates. Any UIRs or other initial reports that are completed, be prepared to request more specific information and/or clarification in writing if the information contained in the initial reports is not complete or not understandable. These short reports should be signed and dated by the person completing the document. Sometimes we get third person reports from people who actually have not actually witnessed or getting direct information. So we want to make sure whenever possible to have those signed and dated by the person who actually is reporting or have firsthand information about the incident. This is a copy of an incident report form that we often will use and believe to be a pretty thorough initial incident report. Provider investigation materials and reports. When you meet with the provider to review any investigation materials that they have collected as part of the investigation, make sure to ask for any missing documents that you think they may have. Look to ensure that the documentation completed by a person is signed and dated, or request that it is signed and dated. Some of that is best practice, but if you do have a provider who conducts their own independent investigation, completes a report, it's nice to make sure that that is signed and dated by the author of that report. Medical documents, physician's notes, nursing notes, MAR, physician's record, hospital ER reports, EMS reports, therapy reports, consultation reports. This information can act as a script or a statement of the medical professionals or medical facilities' knowledge or acknowledgement of their actions. If you are getting any professional advice or consultation from a medical professional, I recommend that you try to do something via at least email so that their response is documented and you can have that as part of your case file and verification of the information they provided you. Financial documents, ledger, statements, reconciliation forms, cancel checks, financial audits completed by the provider, a consultant, a banking institution, payee, PPI, etc. Most of these documents completed by the provider staff will typically have like initials and dates. If there's a financial audit completed by the provider or another source, try to ensure that it's dated and signed by the author. If there are some financial ledgers that are missing initials and dates, try to get that verified so you know exactly who wrote on those documents. Staff documentation would include staff notes, shift reports, staff schedule, logs completed by the provider, witness, PPI, etc. They typically include initials with dates. If an important staff document is unsigned, attempt to find out who the author is and obtain a signature and date for verification. Okay, I'm going to talk about written statements, and here's a written statement form that we use and does contain all of the criteria that we usually look for in a written statement. Written statements. All interviewee statements should be completed on a professional written statement form. At times, an interviewee may need to use an alternative method of dictating and signing their statement. Make a note of the reason for this. That would mean that there could be times when your interviewee is unable to write or even sign their statement. So please make note of that in your report or on the statement itself. The statement should include identification information, but is not limited to the interviewee's name, address, phone number, date of hire, date of birth, social security number, optional, but we're going to need it if we're looking at a case for Abuser Registry, employer, date and time of incident, location of interviews, and others present during the interview. Each page of the statement should be signed and dated by the interviewee. The interviewer should sign and date the statement as well. The statement should be completed in its entirety by the person, the witness, the PPI, the individual other, or explain why not in the report. If necessary, with an explanation provided, the IA can complete the written portion of the statement with the interviewee's signature and date and a notation on the statement regarding who wrote the statement. Best practice would be to have a witness sign the statement as well to confirm the accuracy of the statement. If the interviewee cannot sign the statement, note this. When needed for additional information and/or clarification, include a question and answer script on the written statement or other designated document. The question can be written by the interviewer, but the answer must be completed by the interviewee with their signature initials and a date next to each answer, or note the reason why not. Include a follow-up interview with written statement when needed. A drawing depicting important information about the incident can be utilized as written evidence and should be signed and dated by the person who completed it. This is a copy of investigation case notes that I got from a county board that I think is a good form to use. It keeps your interview notes more professional and kind of, I think, also encourages you as the investigator to write a little bit more neatly and concisely. IA interview notes should be completed by the IA during interviews or in any situation in which information evidence is being obtained. The notes should be illegible, and best practice would be to have the IA sign and date those notes. Photos as evidence. Photos taken and used and as part of the investigation should include the date taken and who took the photo. It is often necessary to include the context and a description of the item or the scene, etc., being photographed. On the back of the photo, somewhere in the photo, make sure that a date that it was taken, who took it, and maybe a little description of the context is very important. Collecting evidence. Email correspondence, social media, text, SSA case notes should be collected when being used as evidence. Acknowledgement by the author, best practice would be via signature, initials, and date. So in some way, we want to make sure that we are noting whose social media, whose text, whose SSA case notes we are using as part of the evidence. So make sure that's documented. ISP, BSS, and other plans associated with the individual should be collected when pertinent to the investigation and should include signature sheets. Collecting important verification. Relevant training documentation, certifications, etc. should be collected when important verification is needed. Signature and date sheets should be included. Transcription of audio, video recordings. Transcription of recordings should be obtained when pertinent to the investigation. Verification of the date and who the recordings occurred should be documented. PPI, witness, individual, and other information such as history, work, training, etc. should be obtained when pertinent to the investigation with verification of the date and how it was obtained and collected. And Honore talked a little bit about this as well, but it's very important that that information, especially names, agencies, etc., the spelling is correct to the best of your ability so that we can put that information as in our documents for Abuser Registry. It's very important to have correct spelling. Other things we will be looking for, as I noted in the written statement, would be date of birth, social security number, date of hire, PPI and witness address, phone number, and employment status. Okay, I'm going to turn this over to Steve Sizemore.
Good morning. My final portion of this presentation focuses upon the clear and convincing standard of proof that applies to the Abuser Registry process and its practical implications for investigative agents. I recommend that as you receive case assignments, you identify those cases likely to receive registry consideration and immediately calibrate your investigation toward the more rigorous, clear and convincing standard. The clear and convincing standard is greater than the preponderance of evidence standard that you utilize daily to reach case dispositions and recommend MUIs for closure. This relatively low standard of proof is consistent with the client service focus of administrative investigations, which seek to identify incidents and problems that present risk of harms to individuals and to develop prevention plans accordingly. As you can see from the definitions provided on the slide, there is a significant difference between the preponderance of evidence standard as contrasted with the clear and convincing evidence of standard. In terms of the preponderance, it's simply More likely than not, when we look at clear and convincing evidence of standard, this is producing a firm belief or conviction without hesitation about the matter in issue. In daily practice, I believe the amount of evidence IAs collect in most investigations generally is commensurate with that preponderance of evidence standard. You recommend closure, and your assigned regional manager conducts a cursory ITS review of the case, as they only have the investigation report present in ITS to review. If the report logically supports your conclusion, as it typically does, the regional manager officially closes the case. This screening process is only moderately rigorous. Anxious to keep pace with your workload, you move on to your next case due. Problems potentially develop when DODD registry investigators later review that closed case for registry processing. We review the report together with the complete investigation file, looking for consistency and support between the investigation report and related documentation. The preponderance of evidence standard is no longer sufficient. Rather, we apply the more stringent, clear, and convincing standard to determine whether to proceed forward. We don't want to deprive that person of their livelihood and wrongly place them on the registry for something they did not do. Historically, when department investigators discover discrepancies or missing information within the case file, we telephone the IA with questions. Occasionally, the IA has the answers readily at hand. Perhaps the IA just omitted the information from the investigation report or investigation file. More often, questions necessitate the IA to recontact witnesses or agencies. A time-consuming, inefficient, and often ineffective effort for a case that's already officially closed and an incident that is now several weeks or even months old. Some witnesses are no longer accessible. If they are, memories fade, relevance diminishes, documentation is misplaced or lost, and injuries are long since healed. To avoid the difficulties associated with revisiting an investigation post-closure, the proactive investigative agent immediately incorporates the clear and convincing standard into their investigative approach. One means to that end is to thoroughly explore each of the incident-specific prompts provided at the end of Appendix A as you conduct your initial round of interviews. Mindful that a measure of clear and convincing evidence is a subjective judgment, obtain as much evidence as possible. Remember, potentially you may have to defend your findings in a formal registry hearing with the PPI's representative attempting to refute the logic of your conclusion. The more thorough your investigation, the greater influence upon the hearing officer's decision. Please don't misconstrue me as suggesting that you do less for MUI investigations that appear unlikely registry candidates. All Appendix A MUI investigations require protocol compliance. I am suggesting, however, that you do a little more for those cases that appear to be likely abuser registry candidates. So let's move on to the elements of the proactive approach. Beth provided an exhaustive list of evidence and documentation earlier. I want to stress that some evidence and documentation is particularly essential in reaching the clear and convincing standard. That evidence, however, often will not fall into your lap. Sometimes you have to actively seek out and secure evidence before it is irretrievably lost. Photographs of bruising is one example of time-sensitive evidence. Keep in mind that visual, tangible evidence of even minor bruising or redness, which soon fades away, nonetheless can be very influential in the registry process. Yet frequently, investigation reports indicate redness faded away before photographs were taken. In some cases, IAs passively depend upon provider staff to take photos on their own initiative. If provider staff don't do that, that visual evidence is lost forever. It is worth the IA's effort to be proactive in ensuring that any evidence of injury is preserved through properly labeled photographs. Similarly, as Beth mentioned, video footage from a store, bank, or other public location sometimes can provide valuable investigation information. Such footage often records on a loop, erased after a prescribed period of time. Promptly identify and secure such evidence. Sometimes physical objects are used or broken in the course of a physical altercation. Once again, time may be critical in securing these items. Don't be a passive investigator. Actively seek out information, physical evidence, and documentation that will strengthen your case. IAs generally do a good job of interviewing persons directly involved in incidents. However, interviews of carefully considered collateral witnesses sometimes can provide information that places a case over the top of the clear and convincing threshold. Collateral witnesses sometimes can place an incident in context of an ongoing relationship or situation. They also might offer input into the relative credibility of case principles. Finally, they might have secondhand information that, while not as impactful as direct evidence, still contributes to the investigative whole. Consider, for example, the individual who reports abuse by her first shift staff person who works alone with the individual during the day. Might it not be useful to speak with a second shift staff person who relieved the PPI? What did that staff person observe at the change of shift? What did the individual say to that person? In conclusion, actively plan your investigation. Who is most familiar with the case principles? Who is likely to have information relevant to the situation, whether as a direct or collateral witness? Anna Schaefer discussed written statements earlier in this presentation. I'd like to emphasize one additional point. In gathering statements, including those from individuals or PPIs, the proactive IA should attempt to facilitate inclusion of any significant disclosure that the witness made during the investigation interview into their written statement. Ideally, witnesses will include such information on their own initiative while completing the open-ended narrative written statement. When requesting a witness to complete a statement, I often review the topics that we touched upon in general terms upon conclusion of my interview. The recap often prompts the witness's memory to include all significant information within their statement. However, in the event they omit a significant piece of information, you might supplement their narrative statement with the focused question and answer option that Anna discussed as a general prompt. For example, you might write, "What happened when you entered the dining area on Tuesday afternoon?" A statement that includes significant witness disclosures, written in their own words, can be a significant piece of information in an abuser registry hearing. Beth did an excellent job covering the numerous variations of documentation that an investigator might collect in the course of an investigation. I just want to add a couple of contextual thoughts to keep in mind as you seek out relevant documentation. The first question you might ask is, did the PPI's action depart from typical practice or established agency procedure to suggest that something in the situation was amiss? A second question to ask might be, can we authenticate documentation by confirming the exact time at which the staff person submitted the documentation? Of course, documentation should be a record of events as they actually occur, but a proactive investigator might consider the possibility, not often, but perhaps occasionally, that a staff person might fabricate documentation in response to an anticipated or known allegation against themselves or a coworker. Finally, remain mindful that the absence of documentation sometimes can be as meaningful as documentation completed. If a PPI accused of abuse tells you that he responded in self-defense to the physical aggression of the individual, did he document that physical aggression? If not, you may consider the possibility that his report is not truthful, made only in response to the abuse allegation. In conclusion, documentary evidence can be a valuable asset to the MUI investigator. However, sometimes we must consider the meaning of documentation, either as it's written or even by virtue of its absence. Finally, if you've taken the civil and criminal training for investigative agents, you'll recall discussion of alternative incident accounts. Keep that concept in mind as you conduct interviews and build your case to withstand potential abuser registry hearing challenges. The Project Find forensic training program suggests that an investigator prepares for investigation interviews with 3 separate hypotheses to account for a set of circumstances, developing a line of questioning accordingly. You will strengthen confidence in your conclusion if your investigation report rules out alternative accounts, particularly addressing head-on an alternative account offered by the PPI. For example, let's consider a scenario in which an individual alleges that her direct care staff struck her arm after she refused to get ready for day programming because she wanted to stay home that day. She shows a mark on her arm as evidence of the incident. The primary person involved acknowledges that a disagreement occurred that morning over the individual getting ready for work, but stated it was a verbal disagreement only. The individual purposefully inflicted the mark on her arm to get the disliked staff person in trouble, according to the PPI. In the event you uncover evidence to support the allegation, you'll want to also attempt to discredit the alternative account as strongly as possible. How? Perhaps you uncover concrete evidence that a physical altercation did in fact occur, contrary to the PPI's assertion. Perhaps the individual has no history of self-injurious behavior, and collateral witnesses familiar with the individual express strong doubt that she would ever purposely harm herself. The investigative agent should conduct interviews and write corresponding reports that demonstrate that interviews were conducted with an open mind to all plausible explanations for a set of circumstances. In closing, your investigation report and file should demonstrate that you were fair and objective, receptive to all plausible scenarios, that you were thorough in speaking to all essential witnesses and collecting all available evidence, and that you were logical in arriving at your case conclusion. In effect, that you were a proactive investigator that reached the standard of proof.
This is you again, and there some contact information. At the very end, we have all the contact information for the presenters. If you have any questions about the abuser registry process or anything, please send me an email, and my email is listed there, edith, edith.deal, D-E-A-L, at dodd.ohio.gov. We will take a look at all the questions and comments that come in for not only future presentations, but also where we can answer your questions and maybe send out frequently asked questions.
This is Scott Phillips. I just wanted to, in closing, I know we're here at our time and a few minutes over, I apologize, but I wanted to reiterate the importance of the abuser registry process. You guys are critical in all that you do. The information you provide is so important to the work that we do. And we wanted you to have a really good understanding of the steps from the time you get it to the time we get it, to know what all happened, because sometimes I know it seems like some of these take some time, and in order to get the registry approved through the legislature, we had to provide due process. We had to make sure that we did the right thing. And so this was kind of another way of sharing with you the importance of the steps for the registry, the follow-up, and again, reiterating the importance of the work that you guys do on a routine basis. So again, appreciate you taking your time out. Know that we're here to work with you through this coronavirus situation. We're going to get through these together, working together. I know it's kind of been an upheaval for everybody involved, and you know, we're still going to protect individuals. We want to make sure that you guys are protected in the work that you do, and that together, you know, all of us working together, we're going to make it through it just fine. I want you to know that. So appreciate it again. Thanks for the work. Thanks for the opportunity to talk to you today, and be safe out there.